Hi, this is Professor McLaughlin providing you with I don't know how brief it will be, but briefer than it would be in the classroom lecture on Chapter 3, the U.S. legal system. This is an intimidating chapter for students, and it should really be renamed the court system. This chapter focuses on the courts, court rules, fundamental concepts for how cases make their way to courts at the state and federal level, and then how courts then decide whether to accept particular cases through concepts such as jurisdiction, personal jurisdiction, subject matter jurisdiction, and then some threshold questions, which are all court-related questions, whereas the U.S. legal system more broadly is how laws are made at the state and federal level, and how the Constitution created our government at the federal level, and then how the states grew from that to replicate the government. But obviously that's outside the scope of this course. But I do like to kind of mention that it's not misnamed, but as you can imagine, this class needs to go from 0 to maybe not 100, but at least 55 a little quickly to bring everybody up to speed on law and how it functions in society, which is really what graduate work in law is all about as well. So lots of dense, really important topics in this chapter that you need to understand, and this brief lecture will just hopefully give you some foundational support to help you understand that. All right. So jurisdiction is a very fundamental, big question. What court do I belong in? And I want you to free yourself a little bit to rather than just accepting a news article that tells you that this court heard a certain matter, to understand what went on behind the scenes where everybody understood that the court had the power. How does a court have the power to even hear that dispute? When parties have a dispute, where do they go? Who knows that? It's not some mystery. And frequently lawyers might get it wrong and send a case to the wrong court. But then who really ultimately decides that this case can be heard by this judge? And that's the court itself. So the lawyers involved in a matter, the parties involved in the matter, the issues involved in the matter are all floating, kind of orbiting the sun, so to speak, which is the court itself, which has its own integrity it must maintain, its own rules it has to follow and abide by. Courts are not all powerful, and I think it would make you a better business person if you understand the struggles that go on, rather than accepting wholesale courts have a lot of power, they never really do justice, lawyers are lawyers, whether they're judges or advocates, and it's really not quite that simplistic. And when you get to the federal level, or even at the state level with administrative judges and administrative law, like the Internal Revenue Service, there are valid struggles that go on to understand, am I in the right place? Do you have jurisdiction over me? Can you make a decision about my dispute? And that is a very fundamental question. So jurisdiction is given by a constitution. Jurisdiction is given by the U.S. Constitution State courts are created by state constitutions and state civil codes of procedure, which tell a court what it has the power to hear. So original jurisdiction is all about cases when they first get to the legal system. That very first lawsuit. I'm suing you because I slipped and fell in your store. You're suing me because I'm a vendor that committed fraud or breached a contract. You as a client, you as a corporation. Where do I go first? Wherever I go first, doesn't matter. Wherever I go first, that's original jurisdiction. Then if I lose and I want to appeal, I'm going to go to the next court. And that's not the first court. First court is already done. I'm going to go to an appellate court. An appellate court has power to review a previous court's decision. Not everybody has that power. Only appellate courts have that power. We call that power jurisdiction, appellate jurisdiction, the power to review a previous judicial decision. Because you're asking the appellate court to decide if the lower court made an error. Was there a boo-boo? Did someone get confused? Was the law not followed? Was a mistake made? Not every court should be able to do that. Only appellate courts can do that. So jurisdiction is very fundamental. Does the court have power over me? Is it my first time as a dispute? Think of me as a dispute. Is it my first time entering the legal system? Or am I asking you to review what a previous judge said about me? So that's jurisdiction. And then, like in onion, there are layers of jurisdiction. So does the court have power over me as a person? Because I live in the county of Orange, but the accident or the breach of contract happened in the county of LA. And I'm a corporation and I'm located in the county of Orange, but the vendor who breached the contract is in the county of LA. Who should have power over me? Okay, in personam jurisdiction, power over me as a corporation, power over me as an individual. Where do I have a right to file this claim? Okay, so courts have power geographically over individuals, and sometimes there may be a time when you're looking at a particular dispute and you're like, yes, one person lives in Orange County or one corporation is located in Orange County, but most of the other parties, the vendor, the presidents, the contract was signed in LA. At some point, the Orange County court may have power over me, but it makes more sense to be in LA County. Because, believe it or not, courts are really concerned with efficiency. To get this dispute resolved quickly, I want this dispute to be heard in the place that makes the most sense, that I have the power, the court has the power to hear it, but also it's efficient. Where are the parties traveling from? Where are the most contacts? Where did most things happen? Where are most things located? So a very efficiency-related argument for in personam jurisdiction. Having said that, courts, it would be a stretch for two persons with a contract dispute in Arizona to wind up in Orange County Superior Court. There would be no jurisdiction for the Orange County Court to hear a matter that happened in Arizona. All the parties are domiciled in Arizona. So that's a jurisdiction calculation. And then that's an in personam jurisdiction calculation. A subject matter jurisdiction calculation looks at what kind of case is it? Is it a contracts case? Is this a family law case? Is this a tort claim? Is this a bankruptcy? And do I have as a court have power over that subject matter? So there are criminal courts. There are family law courts. There are bankruptcy courts. And those courts are limited by subject matter jurisdiction. So those kinds of organizational decisions are given to the courts. Pardon me, I have to cough. I'm so sorry. Given to the courts through either through the Constitution, through the Civil Procedure Code. But for your purposes, what I really want you to kind of get a sense of is there is an organization, there is a power that the court has to decide that it has over you, and there are arguments to be made that the court has no power over a particular dispute, and those are jurisdictional arguments. So some courts, and typically federal courts, have exclusive jurisdiction over exclusive subject matter. So bankruptcy is federal law, federal criminal prosecutions are federal law, patent, trademark, and copyright claims, which are all intellectual property, are federal, so they'll go to a federal court. And that's another layer of the onion where you want to begin to ask, is this a federal case or a state case? And that's, I don't know if anybody this day and age is familiar with the euphemism, don't make a federal case out of it. You know, federal courts are bigger, they have more powers, state courts are smaller, and they have less powers. They have powers given to them by the federal government, by the state constitution. Things that the feds don't want to dispute, hear disputes for, remain in state court. So, if you can imagine it, if you have a dispute that maybe was activities that involve two different states, how are you going to decide? So California and Arizona, corporation in LA does business with a vendor in Phoenix, Arizona, and they have a dispute. Where's that dispute going to go? Arizona people don't want to drive to LA, and the LA people do not want to go to Arizona. Where are we going to have that dispute heard? Well, where you have citizens from two different states involved, we call that a diversity of citizenship case where you may have access to the federal courts. So rather than allow the parties to fight over a kind of a tug of war, where are we going to go, LA or Phoenix? We have rules that say if you have diversity of citizenship, corporations, individuals from different states, you have access to the federal courts. And we call that diversity of citizenship cases, and where in situations where you might have access to federal or state courts, we call that concurrent jurisdiction. But there are specific rules for how you get into federal court. Federal jurisdiction is over things that are a federal question, which is federal law, U.S. law, and diversity of citizenship cases, and there are also dollar amount requirements. So state jurisdiction is everything that the feds don't want, everything falling outside of exclusive federal jurisdiction. So one really interesting case that demonstrates this is the Hertz Corp v. Friend case. And so now we'll talk a little bit about cases to help you apply kind of what you're reading and learning in these chapters. And the question in this case was, and I encourage you to maybe pause and read the case before you listen to this lecture, and read the chapter for sure before you listen to the lectures. But the issue here was, you know, there were activities in different states, there were activities all over the place. Where should this decision be heard? You know, do I look where the corporation is incorporated? Do I look where it's headquartered? How do I decide, particularly for a corporation, where the jurisdiction is? And if you leave it up to the advocates, the parties who are the lawyers who are representing the parties, they're going to go for the place that makes the most sense for them. But at the end of the day, the court has to decide on behalf of the entire dispute, the plaintiff and the defendant. And so the court has to make a decision. And remember that we're in a legal system where there's precedent, meaning if a court makes a decision, another court needs to follow it. So this laborious decision-making and analysis that goes on, this Hamlet-like hand-wringing where I'm trying to make a decision, is because when a federal court makes a decision, this is a U.S. Supreme Court in the Hertz case, the rest of the country has to follow it. So they make decisions infrequently, and there's a lot of soul searching, and obviously a lot of politics involved. That's the nature of our system. If you want to change it, you gotta be proactive and vote. And but as it is right now, the U.S. Supreme Court making a decision, all the other courts have to follow it. It's the end of the road, so to speak, in terms of appellate jurisdiction. So 2 California residents sue Hertz. How does a court decide if it's got jurisdiction? A lot of cars get rented in California. It's a drive-y kind of place. Got to have a car out here. On the East Coast, you can take a train. You can take a subway in New York, but lots of trains in Philadelphia and New Jersey. Hertz is incorporated in Delaware. It's headquartered in New Jersey. California residents sue them. Where should they go? Do they go to federal court? Do they go to state court? And what state court? So the court looked at previous decisions in this matter and decided it wanted to come up with a new test, a new analysis for how to decide who had jurisdiction, and that was the nerve center approach. That, I don't need to just look at the headquarters or a single place of business, and instead I want to know, or where they do the most business. Where does Hertz rent the most cars? What's a good way for me to come up with a rule for other courts to follow? And that rule was the nerve center approach. We want to come up with a decision-making paradigm that looks at the nerve center of the business. Where is it all happening? And the court concluded in this case that the nerve center is usually the headquarters. And that was true for this court. And the headquarters was in New Jersey, and that was going to be where citizenship was, and an important jurisdictional decision for the court in this dispute. So the U.S. court system is like a big triangle, and I'm sorry I don't have the whiteboard open. I have not graduated to that ability on this software system. But I want you to imagine a triangle around this slide where the fattest part of the triangle is the lowest bullet point. It's the federal trial courts. It's fat. There's a lot of them down there. And then you get a thinner part of the triangle is the intermediate courts of appeals. There's fewer of them. And then the very tip of the triangle is the U.S. Supreme Court. So it's a hierarchy. You enter the system at the bottom. You have lots of trial courts. You have limited right to appeal and fewer courts. And then you have one final shot, which is the final recourse, the final court that can hear your case, which is the U.S. Supreme Court. The state court system's no different. Triangle on this slide will show a lot of state trial courts at the bottom, fewer intermediate courts of appeal, and then one final state Supreme Court. So in addition to jurisdiction, courts also ask 3 additional or threshold questions. Does this party have standing to sue? Is this a justiciable controversy? And is the dispute ripe for resolution? So these are huge questions of law. I'm going to spend 3 minutes on it, which doesn't do it justice, but that's all we have time for. So standing to sue is a theory that says you really can't sue unless you're the one who's harmed. So if you have a friend who is involved in a breach of contract and the friend doesn't want to sue, you cannot sue on their behalf. Sometimes parents can sue on behalf of their children. That's different, especially minors or adult children who are incapacitated, like some of the cases where you want to terminate a feeding tube or stop a breathing apparatus. But standing to sue says you only have a right to sue if you were the person harmed. You cannot sue on behalf of mankind for the most part. You cannot sue on someone else's behalf. Case or controversy says it has to be something that a court can resolve. You cannot ask the court to declare that there is a God, declare that love exists, prove that unidentified flying objects exist. It has to be a dispute a court can resolve, something justiciable. And then finally, ripeness says you can't sue too soon and you can't sue too late. So best examples of this are cases that involve terminating a pregnancy. You need to be pregnant. Can't sue before you've conceived. And you have to sue before the baby is born. Another great example, or very, very factually good example, are same-sex marriage cases where you have to sue at the time. It's kind of why when same-sex marriages, it's not why, but you'll get a lot of couples that when same-sex marriages become legal, they'll go get married. And then if it becomes illegal in a specific state, you cannot sue to declare same-sex marriage constitutional or unconstitutional unless you're actually married. It doesn't, the court doesn't declare things as valid or invalid. You have to sue. So the case before the Supreme Court right now for same-sex marriage is an Ohio couple. And I don't think that decision's out yet. We would have heard in the news. But an Ohio couple was validly married in another state. Ohio does not recognize same-sex marriage. They also adopted a child in another state, and Ohio, since it doesn't recognize the same-sex marriage, did not recognize the adoption as valid as well. And so that case made it to the Supreme Court, where the Ohio couple was challenging Ohio's right to not recognize a same-sex marriage from another case, as well as an adoption from another case. That's ripe. An adoption happened, marriage happened. You can't do it too soon. That's ripeness. So these next couple of slides, the steps in civil litigation. So many of you are very familiar with this because there's a lot of TV shows that show you all this stuff. But just quickly, informal negotiations where you say, hey, I'm not feeling too good about this breach of contract. Can we talk about it? Can we have a discussion? Yes, that doesn't go well. Okay, I'm going to sue you. Fine, sue me. And then there's rules within the civil litigation, the civil procedure code that says, I have a right also under the Constitution to be notified that I'm being sued. And that resulted in service of process. And so service of process is where you get the sheriff or somebody over 18 to serve somebody else and say, hey, just so you know, you're being sued. And that completion of that process is very important for constitutional reasons, but also for civil procedure reasons. And then everybody has a right to respond after I've been sued. Hey, I didn't do it. Everything they said in the complaint is wrong. Then you'll have pretrial motions, a motion to dismiss this case, motion to compel certain documents be turned over, that kind of thing. You'll have discovery where I get to interview potential witnesses under oath and find out what they're going to say. I get to ask you for documents. You get to ask me for documents. pretrial conferences, jury selection, which is just huge and constitutional and lots of protections. And then what most people are familiar with is what you see, the most interesting part, which is going to be opening statements at trial, examining the witnesses under oath, closing arguments, and then letting the jury know what they really need to decide, what's the law that they're deciding on, and having that law applied to the facts that were in the case. Appellate procedure, for the most part, this slide is really meant to give you an idea. So we've gone through the original trial, and when we go up to the appellate court, we cannot get all those witnesses in there again. The appellate court's going to make a decision based on the record that's provided them from the trial below. You do not get a second bite of the apple, which is a very popular thing to say in law. Your only bite of the apple is your first trial court when you go up, which is why you object and you make sure things get in the record, because if you do appeal, if you do lose and you appeal, that's all the appellate court gets to say. You don't get it. You get a little bit of chance to brief and describe what went on, but for the most part, that's your one bite of the apple as a trial court. When it goes up to the appellate court for review, the appellate court can either affirm what went on in the lower court, request a modification. This was okay, that wasn't so hot, we need to modify what happened below by this, this, and this. They could reverse what happened below, so that would be a reversal. We're going to make a 180-degree turn. Is that right? No, 360-degree turn, go in the opposite direction. Or the appellate court could remand it, which means sending it back to the lower court to look at it again with specific instructions. So those are some words that would be good to know for appellate court decision making. So this chapter is super important for the rest of the course, because the rest of the course talks about cases, and it talks about jurisdiction, and they talk about right to hearing. And so chapter 3 works very closely with the remainder of the course. Understanding chapter 3 and the vocabulary in this chapter is very important for the other chapters for the remainder of the course. These, as I said before, these chapters are building a foundation. This chapter, chapter 4, chapter 5, constitutional law, for what we see moving forward in terms of cases that we're going to read, but also understanding of the specific areas of the law when we get to the chapters that cover specific areas of law, which happen so quickly with these summer courses. Okay, I'm going to end it there.